Good morning. You may be seated. So we're here today on our case number 1CACV160043, Knox versus Staples, the office superstore. Counsel, as you know, each side has allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do, you're in charge of keeping track of that time. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful to you if you would recite your name and the name of your client into the mic. We have read the briefs, and we have studied the summary judgment record, and we've discussed the case in our conference this morning. So with that, you may proceed.
May it please the court. My name is Emily Ward, and I, along with my co-counsel, Tim Berg, represent the appellant in this matter, Walter Knox. Before I begin, I'd like to reserve 5 minutes for rebuttal, and I acknowledge that I will keep track of the time. I'm going to talk to you this morning about 2 reasons why this court should vacate the trial court's grant of summary judgment and remand for a jury determination. The first reason is that notice is not required here. Staples itself created the dangerous condition by balancing the sign, the sandwich board, in the store's entrance on a windy day. Because Staples created that dangerous condition itself, notice is not required.
I don't think that Staples is any longer arguing about notice. So I think, yeah, we can probably get by the trial court's ruling pretty quickly.
Staples does argue that it did not create a dangerous condition by creating this artificial distinction, if you will, between a defective condition and a dangerous condition. That distinction itself is entirely artificial and really just argument. And I'll tell you why. The balancing of the sign near the store's entrance on a windy day itself is the dangerous condition. Let me give you an example. Let's say that Mr. Knox walked into the Staples store, and a gust of wind with him knocked the sign onto his leg. In that case, it's entirely the entire dangerous condition is Staples placing the sign on the entranceway on a windy day. I submit to you that had the sign not been in the entrance, had the day not been extraordinarily windy, this would be a different scenario. But here, the trial court took matters into its own hand and granted summary judgment, in our opinion, because he just didn't think this should go to a jury.
Does it matter what caused the sign to fall under your theory?
No, I do not think it does. I mean, we cited case law to you that the wind cannot be a superseding cause, as a matter of law, especially because in this case, the wind was in an entirely anticipated condition here. It was entirely foreseeable. I mean, that's the exact reason why Staples brought in the sign from outside, is because it was windy. You even saw in the record testimony from Staples employees that they knew it was possible that the wind could knock over the sign on the entranceway. And in fact, the only reason that Mr. Simmer, one of the store's employees, even set it there was because he had to quickly go attend to a customer at the register. So he placed it there for a quick moment, didn't secure it, even though he knew it was a windy day and he knew that the wind had a possibility to knock it over.
Is there any question about what caused the sign to fall?
No, Your Honor. And in fact, we cited some portions of the deposition transcript. For example, Mr. Simmer says, yeah, depending on how you leaned it up against it, correct, there are potential chances for it to fall forward. In fact, the 30B6 deposition of Staples, the individual remarked, absolutely, the wind could have knocked it over. So I think your question is it possible that something else caused the sign to knock over? I think, at the very minimum, that's an issue of fact, but there is nothing in the record to suggest that it was a customer or another third person or that it was Staples itself. I mean, almost Staples agrees that it was the wind, and everyone kind of acknowledges that.
Is there anything in the record that would indicate another cause for the sign to fall?
Absolutely not.
So the only belief from the depositions in the record is that it was the wind that caused it?
Absolutely. I believe page 45 of the Rule 30B6 deposition is where Staples admits, absolutely it was the wind. I mean, they use the word absolutely. It was the wind.
Do you have the record there? What's the question? I read it this morning, but I forgot it already. What's the question to which the 30B6 deponent answers absolutely?
It is,
do you have that? Or
sure, I do bring it actually. Question. There's been an accusation that the wind knocked it over. Do you think that the wind knocked it over? Answer. Absolutely. Question.
Okay.
Why do you say absolutely? Answer. Because I've seen it fall outside when it was windy outside, so if it wasn't secure behind this, I assume she means the wall, I absolutely think the wind could have.
okay.
So
Does it matter to your theory of the case whether a customer could have inadvertently knocked it over?
I suppose it could in certain scenarios. I certainly think that makes Staples' reliance on Preos more convincing because in that case, it was a third party that kicked the rocks into the entranceway, creating the unreasonable risk of harm. But here, however, we have nothing to there's nothing to suggest that it could be a customer or another third party. That would just be pure speculation. There's nothing in the record to suggest that.
Well, your theory of the case is that the way the sign was situated was risky, and the risk was it would fall.
On a windy day. And I know that may seem small, but I think that really changes the calculus. I mean, let me give you an example. Striking a match is not unreasonably dangerous, right? We do that all the time. Striking a match when you smell gas, that's a different scenario. I think, there's a meaningful distinction to be made there, and I think that Staples' decision to balance the sign, behind that metal guard, you see with the automatic doors, balance a sign 2 feet away from the entrance on a windy day, a day that is so windy. I mean, these sandwich boards are rather large, too, by the way. They're not, it's not easy to knock them over. So the fact that, they decided to balance it on that day, knowing it's windy, that's what we allege here was them creating the dangerous condition that eventually led to Mr. Knox's injuries.
Does the record show how big the sign was and how heavy it was?
Yes, the record, it doesn't show how heavy it was. Mr. Simmer remarked that it was quite heavy, I believe is the term he used. And I want to say that it's 4 feet, 4 feet tall at least. The record does support that.
And does the record show does the record describe what we all know to be the entrance to a Staples store?
The record describes
that kind of airlock situation, which I don't want to assume unless it's in the record.
I know that there is a citation in the record. I can't remember exactly offhand, and I can supplement that for the court's edification. He definitely mentions that it's 2 feet from the entranceway, and that there is automatic doors that would open when a customer prompts. It's not that you have to physically open the door. I do believe that there is a citation in one of the depositions, but offhand I don't know that for sure.
Well, just to follow up on the question that Judge Johnson asked, so you're telling me that if it had not been a windy day, there wouldn't be a cause of action here?
I don't think that, to be honest, in that situation, perhaps summary judgment would have been appropriate, because would that then in and of itself be an unreasonably dangerous condition? I don't think that perhaps is the case. Perhaps it is. I don't know the exact circumstances, but Arizona case law teaches that whether or not something is an unreasonable risk of harm depends entirely on the circumstances. Here, that, I think, Judge, you make a great point. Could that be an unreasonable situation in another case? That's possible. I think unlikely, but here we have the wind. We have the fact that all parties agree, especially Staples, the most important party, agrees that the wind knocked it over, or that it's, more likely than not, I suppose. So you really have that situation where it's windy, he knows it's windy, he doesn't secure it. I mean, I think that there's at least an issue of fact of whether or not, they put it in their traditional location that they do. It's supposed to be secured behind a security pillar of sorts.
There is one of our older cases called Rhodes versus El Rancho Markets, where we basically said it doesn't matter. This was a slip and fall in a grocery store. And we said it really doesn't matter if the hazard arose from the carelessness of the grocer, the plaintiff customer, or another patron. So apparently the hazard can arise from really any source. It's the question is was the company negligent in allowing the hazard?
And I think here we have that unique scenario where, the Staples is balancing this large sandwich board in the entranceway. I think had the sign not been in the entranceway, that might be a different issue. That might be a case that's more appropriate for summary judgment. But here you have the trial court taking, kind of matters into his own hands, or into its own hands, and saying, well, it hasn't happened before, so, why are we here? We don't need to be here. Let's just grant it on summary judgment. But I think the critical distinction is that Staples created that risk of harm and did so, in my opinion, obviously unreasonably, but I think that's really for a jury to decide. And it's more appropriate for a jury determination. As you all well know, there's a bunch of Arizona opinions that detail why a negligence action, the breach of standard of care, why that's appropriate for a jury. And that is uniquely involved here. We rely on juries as a matter of our peers to tell businesses like Staples what is appropriate and what is inappropriate, what is unreasonable, what is reasonable. And here that's exactly what needs to happen. It may very well be that a jury tells Staples, you did everything right. Mr. Simmer, I believe he was a 19-year-old employee. He had a customer at the register. He made a split-second decision, and it may have just been an accident. However, a jury, and not the judge, needs to make that determination. I want to speak a little bit about Preos quickly, unless you have...
Actually, I wanted to hear about that. That case, the Prius case, that was a flower bed, a planter, rocks in it, I guess railroad ties or a border around it. The case kind of goes off in a different direction, but I think what Staples is saying is that you could analogize this case to that by saying that the placement of the sign is the establishment of the planter, and since we don't know what caused the sign to fall, and since we don't know what caused the rocks to go out onto the sidewalk, this is not a defendant is the actor case. How would you respond to that?
So a couple different points there, Judge. First and foremost, Preos is a case where I agree with you that they didn't necessarily think that the defendant itself was the creation of the risk, right? I mean, they even have a paragraph in there saying that there was no evidence here that the defendant created the condition. But Staples relies on this rather, in my opinion, I think it's just, this is an old case. This is from 1981, so over 35 years ago, where there's this distinction between what's a creation of a defective condition and what's the creation of a dangerous condition. And it's they rely on this case of McGuire, which is from the 1960s even, that creates that distinction. But if you look at the case law now, really, even since Gibson, the test is looking at, you have a duty, right? In here, Staples obviously has a duty as the owner. And then you look at, was the scope of risk foreseeable? And that's really what the test is. It's not this artificial distinction between a defective and a dangerous condition. That's really missing the point. Preos involved, what they thought to be customers kicking up the rocks into the entranceway. And that was not necessarily anticipated by Preos. Here, we have Staples itself deciding to balance the sandwich board against the wall, which is, effectively there's no change in the causal events between them, balancing the sandwich board and it falling over, other than the wind. And the wind, as a matter of law, as we've cited to you, like cases in Young, other cases, the wind, because it is foreseeable, the wind is not, it's not a superseding cause. So here you have to look at Staples created the danger, which is unlike Preos, where there really was no assertion that the business had created the danger.
Well, that wasn't the argument.
I understand, but they did make that distinction in Preos, is that, and to be honest, too, McGuire, which Preos relied on, also made that distinction, saying there's no evidence here that the defendant created the danger. I think when you look at cases like Safeway, Safeway stores v. Cone, where they look at, hey, everyone knew that the rain was happening, they saw the rain pouring down for an hour or so, that puts the business on notice that, okay, we're going to have to maybe, the circumstances have changed. We're going to need to, heighten the reasonable care that we're going to use. But I think here, that's a question for the jury. And any question that you're asking with regard to whether or not what Staples did was right or wrong, or at a very minimum, whether or not that was a dangerous condition, looking at Markowitz v. Arizona Parks, where reasonable people could differ as to whether the danger of some injury is foreseeable, it's a question for the jury. I'll leave my remaining time. Thank you.
Good morning, Your Honors. I'm Michael Herzog. I represent the appellee Staples. Before I begin my argument, though, this is the 75th anniversary of Pearl Harbor, and I feel in a public forum I feel compelled to remember the people who fought and died there and who have fought and died for us to be able to be here in this kind of a forum, so I apologize for taking the court's time for that.
No need to apologize.
It's interesting that counsel says Proust is a 35-year-old case. It is a Supreme Court case. It has never been questioned. It has certainly never been overruled. And the Cohn case that she cites is from 1965, 16 years before Proust.
Why did you say I like the cases that are in the reporters before they got big?
And the distinction.
Or before they got big.
Online? Are they online?
Well, as someone still has the books in my office because I can't read them online. But in any event, Proust, the Proust distinction continues to be cited by this court and other Arizona appellate courts on a very regular basis. I shepherdized Proust last night, and I didn't bother to take the cites off, but it gets cited fairly frequently. It gets cited by, as I said, this court in the last few years. And the distinction between a defective condition and a dangerous condition is brought up consistently by the Arizona appellate courts. And first of all, I don't know that there's any evidence to even find that the leaning of a sandwich board against a counter is a defective condition, but it's certainly not the condition that caused the accident to occur. In this case, the accident occurred because the sandwich board had been blown over. If it was blown over, all of you asked, what is the evidence? No one really knows how the sandwich board came to be in the entrance. Plaintiff's deposition, he said he didn't see it. All these people from Staples were asked to speculate about it. Mr. Seimer puts the board up against, he knows that he puts the board up against the railing or the wall. And then he goes off to deal with a customer. Mr. Seimer, Ms. Cochran, all of the three employees from Staples say they hear the sign fall.
They only hear one clatter?
Right. They hear the sign fall because wherever they are in the store, and they rush to the front of the store. That's the only testimony about how this accident occurs.
Let's put that in perspective, though.
Sure.
Simmer puts a sign against the wall,
Yes.
then he goes to help a customer. How long a time from the time he puts it against the wall till he hears the clatter?
I think it's a very short period of time. But I don't know that Mr. Seimer. I don't know.
Is it 2 minutes? Is it
I don't
10
know.
minutes? 20 minutes?
I
It makes a difference.
Right. My impression from Mr. Seimer's testimony is it's not 20 minutes, it's not 10 minutes. But I have to say, I don't remember specifically from Mr. Seimer's deposition exactly how long it took.
It's when he's with the same customer that he left the sign to go help.
Right. That's my understanding.
Is he at the cash register? Is he checking? Is it that sort of
Yeah,
helping
there
the
are several
customer?
cash register positions, and he's in one of the
Okay.
register positions. Is what he testified to. And I guess I have his deposition. I guess I could probably look through it if you'd like and try to figure out exactly what he said about it. I don't remember offhand, though, Your Honor. I apologize.
No, but the issue would be, was there anything in this record that would indicate it was anything else but the wind?
No, but then again, there's really nothing in the record that indicates specifically it was the wind, is what I'm saying.
Zimmer believed it was the wind.
Well, Zimmer was asked to speculate, as were all the Staples employees are asked to speculate, could this have happened this way? And they said, yeah, I guess it could have. None of them had ever seen this sign blown over or fall over for any reason inside the store.
Side.
Well, the way I read the deposition testimony and the way Ms. Ward read it to me this morning was that it wasn't just that he was speculating about that. He actually believed that's what happened.
Well, I'm not saying he didn't believe that that's what probably happened, and I apologize if I. What I'm saying is his belief is his best guess as to what occurred. Did not see it happen. He doesn't know exactly why it happened because it had never happened before. And it was a windy day, and he said, yeah, sure, it could have fallen over for
But that
that.
goes back to the shortness of the time. Was there anything else during? I mean, we're talking just a few minutes. There's
no,
really no other reason that it blew over. But
I have no other reason. I can't give you another reason why it fell over. I don't know. I don't think anybody really knows exactly what happened, but we know it came over. But I think when you look at the case law, though, I think Proust is absolutely on point for this.
How is it on point? Because as I was trying to explore with Ms. Ward, I think Proust could have been litigated as this case is litigated, which is, did the shopkeeper establish a condition which allowed another actor to do something that would cause harm? But I don't read the cases being litigated like that. The court just passed over the shopkeeper as actor.
Your Honor, I think that Proust draws a distinction, a very clear distinction, between a condition that might become a dangerous condition if something else occurs and something that is not a dangerous condition. And when you look at the jury instruction, which still cites Proust, by the way, this 35-year-old case that nobody wants, it's the Arizona Supreme Court case, the Raji instruction on premises liability specifically cites Proust in its most recent version, and it's been revised a number of times in the last 35 years. When you look at the Proust case, I think what it stands for is that it doesn't matter whether another actor blew over or knocked over the sign or whether the wind blew it over. Because when you look at the three elements of notice, and it pained me when you said it's not a notice case,
Well,
Your Honor,
I'm
because I
sorry.
absolutely believe it is. But
I thought you had kind of said we're not going to talk about what the trial court.
No. What I said is that to argue about what the trial court said is kind of irrelevant in the Court of Appeals in a summary judgment motion, because in a summary judgment hearing, your job is to independently
Right.
look at the law and the facts. And if the judge, you might agree with the trial judge, you might not, but that's not, at least not my understanding of what you folks do in a summary judgment.
And I apologize, I didn't mean to constrain your argument. But
Let me
Looking at
go
Proust-
through it if I can.
I just want to ask you this one question. On the first page of Proust, where the court is quoting Walker or noting the rule from Walker,
Right.
the plaintiff must prove, number one, either that the foreign substance or dangerous condition was the result of defendant's act. Now, isn't the argument here that the sign on the floor was the result of the defendant's act? In other words, putting it upright in a
I know that's the argument, but I think when you read Bruce and when you read the Raji instruction, the Raji instruction says that the condition was created by the defendant. Created by the defendant.
That's a little bit different than what the case says, right?
Right, but of course, Bruce and Byrne and McGuire are all draw that distinction between defective condition and dangerous condition. And I think when you look at once again, the Raji instruction, which obviously is approved by the Arizona Supreme Court, but it says specifically created. What?
Raji instructions aren't improved by the Arizona Supreme
I
Court.
think they used to be.
They're not anymore.
Not anymore. Okay, well, I stand corrected then. But
Long time.
but
When I was on
But when you look at the case law, which all quotes the Raji, there's a lot of case law that quotes the Raji, created by the defendant. Created by the defendant. This argument of superseding causation, did someone else do it? Is there an intervening actor? None of that is relevant. The question is, did Staples create the dangerous condition? The dangerous condition, if you would, in this case, or this allegedly dangerous condition, if a sign that's, several feet by several feet on the floor can be considered a dangerous condition. But that condition is different than the condition of the sign leaning against a wall. And that is the distinction that Proust talks about. It doesn't matter. The holding in Proust would not have changed if the wind had blown a rock out of the planter onto the sidewalk. In Byrne, it's the fact that liquid can fall through, which is another Arizona Supreme Court case, that liquid can fall through the stands and get on the floor. That does not matter if somebody spilled the liquid on the floor or if the wind knocked over the Coke container that was sitting in the stands and then you had, liquid on the floor. None of these cases have a distinction that says, oh, well, if a third party does something between the time that you create the defective condition that makes the defective condition then become dangerous, that relieves the defendant of liability. It's not a superseding causation issue. It's not an intervening causation issue. It's a question of whether or not the condition about which the plaintiff complains was created by the defendant.
Well, okay, let's get away from the wind and the sign. Imagine a grocery store, El Rancho. The produce department has a table with a pyramid of apples. And, if you take one apple from the bottom, the whole thing's going to fall. And that's what happens. A patron takes an apple.
Right.
What happens then?
I think that you were talking about all these cases, and it was interesting, I think, that Judge Thompson mentioned Rhodes versus El Rancho.
Which I think was lettuce, if I remember right.
It's a lettuce and water. If you
Although lettuce was
lettuce and water, but I think
talking about the pyramid here.
Right, and I think if you look at El Rancho, it is the precursor to the Chiera versus Fries, the mode of operation rule, which actually is a different rule. It's a by its own admission, it's a change and an exception to the normal rule of premises liability. And I think what you have in all of these cases that have been cited by the plaintiff is the same recurring theme in all of these cases, which differs from Proust, Byrne, McGuire, and this case. And that is that you're dealing in a grocery store situation with this repetitive problem, this problem that arises constantly. And I think if you look at Rhodes, if you read Rhodes, you'll specifically see that it's talking about something where the owner of the premises has noticed that this condition arises on a repetitive basis. That is the holding in Chiara. In fact, in Chiara, they talk about it, which is 152 Arizona 398, that dangerous conditions that arise so frequently that they need to be anticipated. And that's really the holding in Rhodes, and that's the holding in Chiara. And that's also the holding in Cone in a slightly different way, the Cone case that they cite, in that it had been raining and snowing for an hour and a half, and during this time, there was a need to anticipate that water would eventually be inside the store because of the passage of time. And you've got the passage of time in Cone, and you've got the repetitive conditions in Rhodes and Chiera, which, even Chiera itself, of course, says that if you apply this exception from the mode of operation rule too broadly, you'll have the minnow swallowing the whale, and you won't have effectively what we have in Raji 1.
So you're saying, do I understand you're right that the grocery store cases, the retail cases are generally have evolved into mode of operation cases, and those are decided under a different framework, and this is not a mode of operation case?
That's exactly right. That's exactly what we're saying. That's correct, Your Honor.
There is, however, another way of viewing the mode of operation rule, in that it's almost not a standard for deciding cases, that it's just a historical recognition that when we moved from service businesses, service grocers, for example, to self-service, there's no employees around to take care of stuff that happens.
Right.
And so we have to devise, we have to have another look at things, because a plaintiff's never going to be able to prove anything because nobody knows what happened. It used to be you got a grocer picking your fruit for you, and now everybody picks their own.
Right. It's really a rule of evidence, effectively, about what you can, assume is happening. Right.
But if your position is that the mode of operation doesn't apply here, or doesn't apply to generally retail, slip and falls.
No, I'm not saying that. I'm saying it would depend on the circumstance. I mean, I don't know. Honestly, I don't know if Staples sells food, right? Or Staples sells cream rinse or shampoos, okay? But if there was something that Staples was selling that it anticipated the customer's handling that might create a dangerous condition on the floor, you'd have, like we stack something up that let's say we created a stack of 5,000 pencils that were loose, and we expected, a customer to pick up the pencil and maybe knock over 6 other pencils on the floor while we were doing that.
So what happens then? That's my Apple scenario. Is that mode of operation?
That's mode of operation. That's clearly mode of operation. Your Apple scenario is clearly a mode of operation under Chiera, which is not applicable to this case. This is not a mode of operation rule. This is not a situation where we anticipated.
I think under the hypothetical, it is a little bit different, because it's the manner in which the apples or the pencils are arrayed that is the risk, that causes the risk.
But it's
not
a
just
recurring.
having the apples.
It's a recurring risk, Your Honor. It's a recurring risk with the common danger occurring because of the recurring risk. There's absolutely no evidence that this sign, for whatever reason, whether blown over, thrown over, atomic war, had ever fallen inside this store. The mode of operation cases, when you read them, when you read Rhodes, when you read Chiera, when you read any mode of operation case, it talks about the recurring danger and the anticipation that danger will occur from the situation on a recurring basis, which is why the mode of operation rule is adopted.
But Mr. Herzog, you are not advocating that under that first prong of, I can't say it, Prius, that you have to have a continuing mode.
Oh, no.
You can create, one can happen the very first time.
Right. But under Prius, we have had to have created the dangerous condition, not a condition that might become a dangerous condition due to something else. All right? The condition that you have to have created.
Isn't the danger you've created here placing the sign up against the wall on a windy day?
No, because that's exactly what Prius says. It's not the creation of a dangerous condition, even though rocks get knocked out every single day. In fact, in Prius, they had more notice, if you would, more knowledge of the fact that this condition led to something that would be dangerous on a daily basis. And it burned the same situation.
Hold on.
Yeah.
It was a proof problem in Prius because they didn't know how those specific rocks got placed on the sidewalk, whether it had been through people walking through the planter or whether or not the rocks were coming from somebody out from the parking lot. I mean, it was a proof issue, and they said there was nothing to show that this was a dangerous condition. The accident happened based on the dangerous condition that you just described. And more importantly, That was a trial.
Well,
This is a summary judgment
but the
issue on whether or not there's an issue of fact here, right?
But I think if you look at, I mean, I understand that issue was present in Prius as well. But I think if you read Prius, it doesn't matter whether the rocks got knocked out by somebody walking through them or not. And certainly if you look at Byrne versus Greyhound, which is cited in Prius, that is not an issue. And if you look at McGuire, that is not the issue. I mean, it's the question of the creation, and we, like I said, we still quote it today. We still see it. You know, if you, I mean, once again, I apologize for not bringing any cases, but if you shepherdize Prius, you see it today. The same distinction is drawn between a defective condition and a dangerous condition.
I'm told nobody shepherdizes anymore either.
That's what my
It's something
students
else.
say, yeah. They don't call it shepherdizing.
Everything we learned is wrong.
I apologize, Your Honor, because I guess I don't know what to call it if you don't call it shepherdizing it anymore. But
Well, let's be clear. Prius says, in order to establish the actual notice of the foreign substance or dangerous condition, plaintiffs were required to present some evidence that others had fallen on or complained about rocks on the entrance ramp on the day of the accident. So, I mean, there was a proof issue there on where those rocks actually came from on that day. Well, that's not the issue in this case, right?
Well, I think Prius addresses both issues. I mean, you're right, that's a different issue, but I think Prius addresses both issues, the issue of the defective condition versus dangerous condition. I think it's clearly addressed in Prius, and Prius is cited for that proposition repeatedly. And certainly, you take cases like Byrne versus Greyhound, which Prius cites. That is a situation where the distinction between defective and dangerous condition is drawn. And I understand what you're saying to me, Your Honor, that you don't like my argument, but
I didn't say that.
but there's a distinction between, if the sign had fallen over and hit, counsel talked about the sign, my time is up, but if the sign had fallen over and hit Mr. Knox, then you could say that the sign potentially leaning up was the dangerous condition. But that's not what occurred. The sign didn't fall over and hit Mr. Knox, like all the cases that they have cited to you about things falling off of shelves and hitting people. The sign does not hit Mr. Knox. The sign falls over, and then Mr. Knox trips over the sign after it has fallen. The fallen sign is the dangerous condition in this case, not the sign. And unless you have any other questions, my time is up. Thank you, Your Honor.
Thank you. Thank you very much. Ms. Ward.
Well, not to play favorites here, but I think Judge McMurdy hit the question right on the money. The answer to your question here is whether or not Staples created the dangerous condition, and the answer is simply yes, and that's based on the evidence in the record. Staples knew it was windy. The sign, they'd seen the sign blow over outside and knew that it was a windy day and that it had the potential to fall over. The Staples employee moved the sign. He then learned that he leaned it against a wall and left it to serve a customer, and he did not secure the sign, which he admits. So this is enough to go to the jury on negligence. This is enough to demonstrate whether or not, or to have a jury analyze whether or not Staples breached its duty of care. During Mr. Herzog's argument, there were some questions about whether or not Mr. Simmer or Staples agreed that the wind had knocked it over. I'm going to cite to page 13 of Mr. Simmer's deposition, where he says, or there was a question about temporal time. I was helping a gentleman check out when I heard a loud noise shortly after I brought the sandwich board in. I asked the gentleman to wait. I walked over, and by the time I had seen what the noise was, which had clearly been the sandwich board falling over, Mr. Knox was on the floor. Did you form an opinion as to what had caused Mr. Knox to fall to the floor? Answer. I gathered that he tripped over the sandwich board, which must have fallen over, and that led to him falling.
So the clatter he heard was the falling sign, and by the time he got there,
Mr. Knox was shortly on the floor thereafter. And then he also, it looks like on page 13 that Staples does some kind of, incident questionnaire after the accident happened. And Mr. Simmer himself said in that questionnaire, it says, describe exactly what you saw. And he wrote, it says, heavy wind from the storm. Did I read that correctly? Yes. outside, knocked our ad sign over just as the customer entered. So that's Mr. Simmer's own words. We're not putting any words in his mouth. And I just want to touch briefly on Prius here. We're not arguing to overrule it. I want to make that very clear. We don't think that this is a very simple case. This is actually a very narrow case where we have, like I said before, the wind, it's near the entranceway. It's kind of a parade of horribles, if you will. But I think, we're not arguing to overrule it. We're also not arguing that it doesn't have precedential effect. But here, Prius does not apply to this case. We know that because the wind blowing over the sign does not create a superseding cause. In fact, it was entirely anticipated by Staples. And if you take Staples' conclusion that, well, the wind blew it over, so, we're not liable for this. I think we cited to you in our papers, the example of a car dealership, the big inflatable gorilla. I'm sure there's Santa up now or whatever. Could the car dealership then just say, well, didn't secure it, but it was the wind that knocked it over into Camelback Road, causing risk of harm? No, the entire purpose of what they did was what created the unreasonable risk of harm here, and that's exactly what happened. Judge Johnson, you talked earlier about whether or not the trial court erred and whether they passed over the notice requirement here, and they did. And the trial court did pass over whether or not Staples created the actual risk, and it cited to this case Walmart, and it doesn't provide the citation, but I went and looked it up. And it's from San Antonio, Court of Appeals case, and notably, when they're describing the rule statement in that case, it doesn't mention anything about the defendant creating the dangerous condition. And I think that that's the problem here. And I know you guys are on a de novo review, but really that's the import here, is that the trial court made that mistake, jumping from a summary judgment decision when it really should have been analyzed by a jury to determine whether or not Staples' decision to balance that sandwich board was a breach of its duty of care. So with that, I would ask that you vacate the trial court's grant of summary judgment and remand to the jury so that they can make that determination and allow Mr. Knox to have his day in court. Thank you.
Thanks to both sets of lawyers. We appreciate your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand in recess.